More right.
Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's true with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
Hey, everybody. Happy Wednesday. It's crazy in my household today, so bear with me. But today, we have the Sherrone Moore hearing from yesterday. The former University of Michigan college football coach who is now charged with, I think, stalking, among other things. Well, he is also in front of my favorite judge in the entire country, Judge Simpson. So we are going to watch that hearing from yesterday. However, we do have a quick channel/life update that I need to get into and discuss with you guys prior to getting into the hearing. This is over a 2-hour hearing, so we are going to be kind of quick with this channel update. However, starting next week, this channel, Squid Pro Quo, will be cutting back on my live streaming to Tuesday, Thursday, and Friday, and Saturday as a bonus day / a collaboration day with other creators, whatever that may be. This is not me burning out. This is a strategic move because I am running 2 channels, Evidence Through Motion and this one, but Evidence Through Motion ties directly into my educational background as a occupational therapy assistant, my corrective exercise specialist certification, and my lymphedema training. And that brand is what I want to focus on and grow more. And the only way to grow that channel more is to give something up. At the same time, I'm a mom of a sick toddler right now. She is right here. Her fever is under control, but you might have to see me duck out for a minute or two. So I'm also prepping for a CrossFit competition, and I'm working outside of the home every once in a while, 3 days a week. So instead of choosing every headline and every case and discussing every drama, we're going to be a little bit more selective so that I can have time to focus on the things that are super important to me right now. So it's going to be, we're going to have to be, in order for me to get what I want accomplished, something has to give. So instead of fewer streams is going to be not only stronger research, but more time to research, more time to um, record and edit and script videos. So this channel stays on top of it because while my other channel continues to grow. So because of the shift, I'm hoping to be better at both because we know that when I do get burned out or overworked or overwhelmed, I get mean. So there's that. So I am hoping to grow my other channel because I love this channel and I love reacting and commentating and being stuff, but that and reacting to things and giving you my truly unfiltered opinion. However, that channel is my heart and soul, what I went to college for, my career that I no longer have. After COVID and all the things surrounding COVID with big medicine, I no longer want that life, but I miss certain aspects of that life, which I'm hoping to bring into ETM. So, in order for that channel to grow, this one has to give up a few things. So, oh, we will still make fun of her. We will still make fun of her. However, Mondays are the day where I am currently seeing clients. I am currently active with clients. I am training for a competition, and Mondays are my heavy lift day. So I am cognitively and neurologically fatigued. My central nervous system is just pushed. I work 4 to 5 hours on Monday outside of the house in a 200,000 square foot facility. So it's a lot of energy. And I realized yesterday when I had to take the time off for my toddler, I felt guilty about taking a day off to take care of my child. And that right there was my like, no. So, mm, you know, we'll still make fun of her. She's just getting, even she's getting boring because her husband unplugged her internet apparently. So she's not acting foolish. So but this is a decision to focus more on the things that are super important to me. And I really like if I had to choose one channel that I wish could grow, I'm probably never gonna make it there, but like Tug size or Charlotte Dobre size, God forbid I ever have over 1 million subscribers. Holy shit. It would be that one, not this one. So however, this one is the monetized one, and this is how I feed my family. So I am going to be keeping up with this one because this one's just fun. That one's a lot of hard work. This one's fun. There may be more recorded videos over here too. I'm not sure exactly what I'm going to do, but as far as live streams go, it's going to be Tuesday, Thursday, and Friday. So that my yeah. Maybe after the competition that might change, but right now I'm like literally training 4 to 5 days a week. I'm sore and my little is sick, and I'm right now hoping that I don't get sick. Because Mr. Swade called me and told me 23 mechanics called out of his work today because of the flu. She's better than yesterday, but we are still not we're not out of the woods, which is why somewhere on this desk, or nope, she has it. The thermometer is sitting right in front of her. So getting into what we actually are talking about today, this is the Sherrone Moore hearing. And if y'all know me and y'all have been here before, you know I love sports, college football specifically. And I love where college football and the law kind of coincide. NIL lawsuits, things like that. However, I also court watch. And my favorite judge in the entire country is a circuit court judge out of Michigan named Judge Simpson, Cedric Simpson. This is hilarious to me because Sherrone Moore, the former University of Michigan football coach, is in front of Judge Simpson. My two worlds have collided. We unfortunately didn't get to cover his last hearing because life and other content came before. Yes, Judge Simpson is awesome. So this hearing is in front of Judge Simpson. Hold on. I have it right there. There we go. This hearing is in front of Judge Simpson. So my two worlds are colliding. So we will get into this super quick. And I do have it on 1.25 speed because God forbid we ever watch something on regular speed here. We'll go to 1.3 and see where that is. And there is a portion of the hearing that does get, they take a break. So we will skip that part. I have it timestamped. So, and thanks for hanging out with me. And Tammy, I normally love you like 100% and I will back you in anything. However, in Olympic ice hockey, go USA. Just saying. Oops. And I am going to put on the voice boost. If that is too loud all of a sudden, like, let me know. And of course, we skip the stuff. And I was so looking forward to him, like, actually coaching Michigan because I grew up a Wisconsin fan just based on growing up in Wisconsin. My sister is an Ohio State fan. I hate Ohio State. So I'm not a Michigan fan, but I was an anytime Michigan can beat Ohio State in their rivalry game, like, my life got better. So I was so upset. Not only from a personal standpoint of like, what are you doing with your life? You're married. But from a like college football fan perspective, like, dude, you had it so good and you managed to screw it up. He was University of Michigan. He was a Big Ten college football coach. That is huge, huge. And like, he just ruined it. And it's, yeah. And hello, Big Mama. How are you? Oh, yes. And Hung Hero, thanks for the 10 gifted Squid Pro Quo memberships. And Hung Hero, thanks for the $2 super chat. We need more. And it's HATH.
That's
the name of the person.
You may be seated.
I lived in Ohio as a kid.
Okay, so the people of the state of Michigan versus Sherrone Moore. Council, please state your appearances for the record.
Good afternoon, Your Honor. Katie Wismerski for the people. Good afternoon, Your Honor.
Whoop.
Michaels, on behalf of Sherrone Moore, who is present in court. Please state your name for the record.
Sherrone Moore. Thank you. All right, you may be seated. And I guess the first order of business, Council, this is your motion for a Frank's hearing, and I'll let you go ahead with that. There was, however, a motion that you had filed in the latter part of last week requesting permission for the court to accept a reply brief. Did the people have a response to that? I will just say this, the information, the legal information contained in there, I already had done the research, so I knew it.
Agreed, and the same, and the court can take it for whatever the court thinks its import is. I plan to respond to it, if only briefly, orally, if that's acceptable.
That's acceptable.
Thank you.
All right, very good. All right, thank you.
And I still have to like, what is it with prosecutors and not owning a brush?
Good afternoon. May it please this honorable court.
Oh, her audio is awful.
Thank you for accepting my motion in reply to the prosecutor's response on this issue. The importance of the reply that I filed is that it states clearly and unequivocally that the relationship between the parties in a stalking allegation matters. It's not stalking if the communication has a legitimate purpose. As stated in my reply, and as what your honor knows, is that under recently published appellate court case in the state of Michigan, it is clear that the relationship between the parties matters. In that case, there was a stalking charge and there was a trial. At trial, the evidence presented that the alleged victim was a probation agent and that the alleged defendant was a probationer. The probationer contacted his probation agent many, many, many times, to the point where the probationer said, please stop contacting me. The probation agent felt harassed. She had her stalking charges filed. At a bench trial, there was a finding of guilty. On appeal, the appellate court stated that the employment relationship is relevant, that the relationship between the probationer and the probation agent is relevant. That It's relevant because what it shows is the contact between the two parties had a legitimate purpose. The contact was for the probationer to notify his probation agent of certain things. What the court said was that when looking at the reasonable person standard of whether somebody feels harassed, you have to look at whether a reasonable person in that position feels harassed, which gets us to what happened in this case. In this case, Detective Welker presented to the magistrate facts to seek an arrest warrant for Sherrone Moore on stalking charges and on home invasion with intent to stalk. In the facts that she presented to the magistrate, she left out the information that Sherrone Moore was the boss of the complainant. The complainant was the executive assistant to Sherrone Moore, who at the time was the head football coach at the University of Michigan. Why does that?
Well, here's the thing. You're also not supposed to be sleeping with your subordinates. So, I get, and bless her heart for arguing the stalking charge. But why are you sleeping? And why did you supposedly, allegedly get pregnant someone who worked for you? Stalking or not, that's creepy behavior.
Matter. It matters because the communications that were presented to the magistrate were 12 alleged phone calls that were unanswered. The 12 alleged phone calls were on a work day. The complainant in this case had not taken a leave of absence. She had not left her job. It was working hours, and she was the executive assistant of Sherrone Moore. Sherrone Moore was never told not to contact her for legitimate purposes. In fact, he was never told not to contact her at all, but that's not what we're here arguing right now. I'm talking about the legitimate purpose. If there are contacts for legitimate purpose, it is not harassment. As I stated a moment ago, the phone calls went unanswered. So there's no evidence as to what the intent of those phone calls were. I can tell you that there was evidence in the police reports that were tendered to me by the prosecutor's office that a text message was presented to Detective Welker by the complainant's attorney as a way to show, look, he's contacting her and she is feeling harassed. It was a screenshot of several text messages. In those text messages were several.
Are you talking about one before December 10th?
There was a screenshot of messages where there was messages from December 9th and December 10th, the days that the alleged stalking occurred.
That were presented, you're saying that there's in the report, because by design, I don't have the police
Correct.
reports, right? So are you saying in the police reports, there are text messages from, what would it be, the 8th and 9th or the 9th and 10th, but prior to the 10th?
Correct. Yes. The police report is where I obtained that screenshot that I presented in my motion. That's how I know Detective Welker had that information, because it was tendered to me in the police report from the prosecutor's office.
How many text messages were in that report?
In that screenshot?
Well, you're saying that in the police report, there were a number of text messages.
There was a screenshot of a conversation. And in that screenshot of the conversation that is on page 5 of my original.
Well, I get that, but it's what were the content of those text messages? I haven't seen. So
motion.
Yeah.
There are.
Because of the time, I'm going to try to interrupt this.
It starts, can you have Dave write a statement? Okay. What is the latest you can get me out? I called him. And then that would have been on Monday, December 8th. Tuesday, December 9th is one text message that says, please answer. And then on the day of the incident, it says, can you call me when you get a chance?
So what was laid out in your brief, those were text messages from various days?
Correct.
Got it. Okay, go ahead.
Yes. That screenshot was presented to the complainant by Detective Welker. Detective Welker asked her about those messages. And in the conversation, which is documented in the police report, Detective Welker was told by the complainant that the first message and the second message and the third message were work-related.
The kind of TLDR from this hearing that I was starting to get just from hearing people talk about it was that text messages were not shared like they were supposed to be. I don't know from what side. However, things just deleted messages during the investigation, but I don't know from what side. and were they intentionally deleted? That is what I'm kind of getting, is things were contextual or taken out of context, and it's just a weird, but I didn't exactly pay attention enough because I wanted to react to it with you guys to see, because I also don't have the time to sit and watch a 2-hour hearing and then rewatch it with you guys. So a lot of my watching it is reacting to it initially with you guys, because why watch it twice? If I'm going to watch it, I'm going to watch it with you guys because that's more fun. And hey, DRTheMost, how are you? The number of messages they can have little meaning. I know someone who sends 1-sentence messages. My sister sends 3 screen messages. Yeah, my mom will sometimes write me a book, and I'll send back like 1-word answers. Same thing happens to Mr. Squid. Like, I'll send him 2-3 sentences, and he'll write back 1 message, and then he'll like remember to send me something else, and it'll be like 4 or 5 messages, but they're only like 1 word. So content matters as well.
The complainant confirmed that they were work-related. The one where it says, please answer, and call when you get a chance, it's my belief that those text messages were also seen as work-related. Those were not part of.
Well, it's your belief, but did she say that, or?
She said to the detective said, was this work-related? And she said, yes, that's work-related. They showed her the whole screenshot, and she said, are these text messages work-related? And the answer was, yes, those are work-related. And then she was asked, are there any more text messages that you haven't given me? And the answer was no. And that's all in the police report.
Okay.
So the reason, again, to connect the dots is that there's acknowledged communication that was work-related during those days, which goes towards the phone calls. She doesn't know if they're work-related or not. We don't know if they're work-related or not. It's our position they were. It was a work day. There's no evidence to show otherwise, because the complainant was able to distinguish between communications that were work-related. She identified the text as work-related.
Okay, let me ask this, because again, I don't have the report. Was information presented to the detective of that these phone calls were actually made?
No, there were no phone records at that time. It was verbally said. There were no phone records. It was presented.
I understand that there may not be phone records, but was there a phone log at all?
Yes, I have to look. I'm not disputing the fact that there were 12 calls made, if that's what you're asking. There were calls made.
But here's I guess what my point is that it doesn't indicate in the swear to that it indicates that the complainant is saying these things, but it doesn't say we look and here they are.
Correct.
All right.
Yes.
So I'm just trying to make sure what was, I guess at that time, known.
It was known that these calls, that she received phone calls from Sherrone Moore that were unanswered. That's what was known.
Okay. So again, I'm just trying to clarify in my own mind. Between the 8th and the 10th, there were phone calls.
Correct.
We don't necessarily have call logs, but there are phone calls. Not that you're not disputing that. But none of these phone calls were answered.
Correct.
Okay. Fine. Go ahead.
At the time of the swear to, Detective Welker knew that there was an employee.
I'm normally at work, but COVID got me. I'm so sorry. I hope you feel better. There's something going around. I don't know if the flu, COVID, there's something, because the little right now has, like, you can see 100.4. So feel better. But I'm glad you're here. Situation being different, I would rather have you, healthy, but I appreciate you being here. I hope this makes you feel not so miserable. And Annie, thanks for the 5 gifted Squid Pro Quo memberships. As always, I appreciate you guys so very much. Yeah, she's trying to run around though, like she feels fine, which is one of the reasons that I have her right here watching her iPad. She has an ice pack because we're trying to manage it without, if it's any higher than this, then I will give her medication, but this is the highest it's been all day. So we're doing better than yesterday. Yesterday, she literally had so much pain in her legs. This growing pains got her with all of this. She was crying and she cried until she vomited. So that's a mama trait. When I cry, I usually work myself so much I make myself nauseous. So she got that one from me. Yeah. What's her normal? 98.8. So yeah, that's one of the reasons that I'm right now we're not giving her I'm not giving her Tylenol. Gave it to her yesterday. Trying not to give it to her today because I want that fever and that infection to actually because that fever is meant to do something. So we're trying to do it from a not holistic health. I believe in, medicine when it needs to, but I also believe that the body uses a fever as a protective measure to fight an infection. Trying to let her body actually fight. I'm actually trying to let her immune system do what it's designed to do without masking symptoms. And she feels fine. She's not crying. She's not in pain, so she says, but she's just got that little bit of a fever. So I'm trying to get her to sit still because she wants to run around like she normally does. And it's like, girl, sit still, sit still. Yeah, a functional medicine approach. Yes, give medicine when it's required, but I gave her medicine yesterday more for the leg pain than the fever. Not the because with the leg pain, she was crying so much, and it's like, no, mama's got to take care of this. But from the fever perspective, I'm kind of gonna let the fever just. Yeah, she loves to carry on ice packs, so she's got a couple of reusable ice cubes that she runs on her lips. That's her. She's done that ever since she was maybe 2. So ever since her right before her 2nd birthday, she found reusable ice cubes, and that's her favorite toy. So she carries them around. She puts them in bowls. So right now she's got a couple of those, and she's literally just running it over her cheek. So yeah, make her Pediasure popsicles. Yeah, she is staying hydrated. We don't do juice in this house because of the sugar content. But every now and then we have Pedialyte in the house, so I mix her water with Pedialyte. I've been giving her more Pedialyte than water the last 2 days. So she's still, everything is normal as far as gaits normal, no pain, still using the bathroom, things like that. She's still, everything is normal except that fever. So no clothes except for shorts and a thin top, and that's what she's got on. But it's also 74 degrees outside, so, when I was a little kid and got a high fever, my mom threw me right in a cold bathtub. Baby Tylenol and baby Advil wasn't even a thing. St. Joseph aspirin was. Yeah, she's anything over 100.5, and I would give her Tylenol, but I'm going to let her do her thing. Could she be getting another tooth? Possibly. Possibly. But her dad was sick on Saturday or Sunday. He had a minor cold. And sweated it out. He'll put on 4 layers of clothes and sit in a room under 3 blankets with a space heater. And whereas I hop in the sauna blanket because it's faster. So far, I'm the only one who hasn't been sick with that. Yeah, and I also did, for those of you wondering, or those of you who hate watch and call me a bad mom all the time. Nobody here does, but it's happened in the past where people have threatened to call CPS on me. I did also message her doctor last night and have been in touch with the pediatrician's office this morning. We just don't think it's warranted to bring her in at this particular time. And hey, Tammy, how are you? So
Employment relationship. And that wasn't presented to the magistrate.
Are you saying that was intentionally done or just done?
I believe it was intentional, but I don't believe that I have to prove that. I think that the fact that it is a relevant and material fact to a stalking charge makes it relevant and makes it a material omission.
Well, I have two questions for that. Do you have any case law where a hearing of this type, which we'll call a Frank's hearing, but may or may not be, but was an evidentiary hearing was then conducted based upon omissions as opposed to false or intentionally reckless statements?
I, in fact, have a case where that was the case in Oakland County, People versus Galloway. We had a 3-day evidentiary hearing based on the omission of relevant information that a tip came from a privileged source. And Judge McMillan at the Oakland County Circuit Court granted my motion for a Frank's hearing, ultimately suppressed evidence that was appealed to the Michigan Appellate Court, and that was upheld. There's quite a bit of case law where omissions.
James, this is circuit court, but this is Judge Simpson. So if you're familiar at all with court, like for or Zoom court and law tubers following court cases across the country, Judge Simpson is a popular judge with the online true crime court watching kind of community. And he is the judge in this case. My two, hello, by the way. My two loves, sports and court watching, are colliding in this. My mind is blowing.
Are considered Frank's violations.
Okay. Okay, go ahead. Well, just one other question before you go on. In paragraph 10 of your original motion, you stated that there were, I guess, fraudulent statements that were made. And I'm trying to figure out what those may have been.
Okay.
Did you want a copy? I have one.
I had a copy.
Pretty much. That's the gist I'm getting from it.
I'm sorry, paragraph 10.
Paragraph 10, you state that Detective
Yes.
Walker knowingly and intentionally or with reckless disregard presented false testimony.
Yes.
And I guess when I read these sort of two, I was trying to figure out and looking at your brief, what are you claiming that's false that she presented?
I thank you. That's a great question.
I know I asked it.
Yeah.
But go ahead.
Yeah. The information that Detective Welker presented at the swear-to, a large portion of it came from information she received from Heidi Sharp, the civil attorney who was representing the complainant in going to general counsel at University of Michigan to disclose this relationship that is the basis of this part of how we got here. Mm-hmm. This Heidi Sharp is when Mr. Moore came to the complainant's apartment, the first person that the complainant called was Heidi Sharp. Yeah. Heidi Sharp then calls 911 and says a series of statements that are in my motion that she did not have personal information of and had no basis for and are untrue.
Okay, that may all be well and good. I understand that portion of your argument. But in paragraph 10, you're saying that the detective intentionally gave false testimony, submitted false testimony.
Right, I'm
now,
getting there.
If I'm the detective and I'm relaying what somebody told me to the court, I don't know that that's false.
I understand. So what happened was after this attorney who was not present gave this information, the actual complainant was interviewed on 3 separate occasions at her residence, which was all on the body-worn camera that I reviewed. The body-worn camera statements made by the complainant were a part of the police report. Then there was a follow-up phone call with Detective Welker to the complainant. The information the complainant gave to Detective Welker conflicted with the information that Heidi Sharp gave the detective. So,
but that doesn't mean that Detective Welker presented false testimony. It just means that, which seems to me to be at the core of your argument,
frustrated with body language.
There was information that was omitted.
Well, if Heidi Sharp, who is not a witness, said something that the actual witness contradicts, then it is false. Or unless you're saying that the person who wasn't present is more reliable than the person who was present. It was contradicted.
Well, I get kind of what you're saying, but you're.
Okay, I'll take it a step further.
Okay.
Heidi Sharp stated that Mr. Moore had a long history of domestic violence against Shiver. Okay. Shiver herself never made those statements. She never gave that information. There is no record of any of that. There is no documentation of any of that. There is no criminal history. There's nothing to support that statement made by Heidi Sharp. Through 3 interviews, the complainant never says any of that and also doesn't support it. She was asked by Detective Welker about assaultive behavior, and she said, no, there isn't any. Heidi Sharp's comments were completely contradicted, and Detective Welker, by submitting to the magistrate Sharp's statements instead of the complainant's statements, was reckless and intentional and false. And the purpose of a Franks hearing is...
I don't know. See, I'm still having an issue with the false part. I get your argument regarding what may have been reckless or an omission, and either reckless inclusion or reckless omission. I get that part. I don't know that, could it be what you're really trying to point out to the court is that by placing that information in, the context of the relationship was placed in a false light, as opposed to what she said being false. Because what she says, what Detective Welker says is, yes, this is what Ms. Sharp said, right? But that's only half the story.
That is a way to look at it, but I do believe it goes a step further, that a detective is an officer of the court. It is their job to investigate. It is their job to present truthful information to a magistrate, to show the picture in order to get, for the magistrate to make a determination. If the magistrate needs information to make a determination of probable cause of whether to issue an arrest warrant, that's a big deal. That's like due process at its core. And in this case, where the detective talked to Heidi Sharp and the complainant numerous times, had a picture of the whole situation, had an ability to ask the complainant if it was true or not, had an ability to ferret out what was really going on here, and then presented to the magistrate in a fair and honest way to paint an entire picture. That's her duty under the law. And in this case, the picture that she painted was inaccurate, not supported by the facts of the person who was present, not to mention the omission of the employment relationship.
Mr. Michaels, I mean, we can move on from here. I mean, we might be saying the same thing in a different way, but it really isn't that it's false. It's that she may have portrayed an inaccurate context to everything that's going on by omitting certain things. I don't know that makes what she said about what Heidi Sharp said false. It's just you haven't given me everything to give context to what she's saying, whether to ignore it or not.
Right. I guess maybe the better language would be reckless disregard, which is also part of the analysis. So I think reckless disregard is more accurate.
Okay. I asked the question because saying that somebody submitted deliberately false information may be a little bit different from somebody that is sort of reckless in what they present. But go ahead.
Thank you. So to get back to what we're asking for, we're simply asking for the opportunity to create a record, to put witnesses on, to create an evidentiary record, to show what they knew and when they knew it and how it was versus what was presented. We believe that we presented enough of an offer of proof as to what was given to me in the police reports. That's the information I want to go on the record. I am not presenting anything that the prosecution doesn't already know. But I believe that in the interest of justice, a record should be made to establish the information that was given to the magistrate with reckless disregard for the truth and the omission of the employee-employer relationship, as well as the omission of the acknowledgement by the complainant that she recognized that communications between her and Sherrone Moore were for business and knew the difference. And acknowledge that during these days in question, there was communications that were legitimate. And if the communications were legitimate, it is not harassment. And if it's not harassment, it's not stalking. May I have one moment? I'm sorry.
If it's
I
not
just want one other
harassment,
question on the last point that you bring up.
if it's not harassment, it's not stalking. So those two have to be mutually exclusive. You can not technically harass me, but you can be what I view as a kind of a weird stalker and even over nice. You don't have to be like a harassing behavior. You can be super nice and just have way too much contact where someone views it as stalker behavior. I don't think stalking and harassment have to be mutually exclusive. My personal opinion. But and that's what to me what it sounded like she was trying to justify, which makes me like, what the hell?
The relationship itself, one can have different relationships. I mean, so a phone call, maybe for business purposes, or might not, right?
Correct.
Or there could be a communication that has a mixed purpose. Correct? I mean,
Correct.
because there are different relationships going on.
Correct.
And in viewing it, as to whether or not a stalking and the harassment occurs, the court would have to take into account that those two things can exist at once, right?
Correct.
Okay.
So in doing that, when there's things that we don't know, we often look at circumstantial evidence. So what's the circumstantial evidence here? The circumstantial evidence here is that it was a work day, it was work hours, the employee-employer relationship was intact. There were text messages that were work-related in those timeframes that these calls allegedly occurred. And it was, in terms of the dates involved, that was the week that Michigan had found out who their bowl opponent was. And there was all hands on
You know
deck.
what bowl it was?
Yeah, it was the Citrus Bowl. That's
You had
right.
to turn it up. No, I don't need to know. I was just asking
I
you.
knew who the opponent was. I couldn't
Okay.
remember Citrus. It was a
All right,
Citrus
it
Bowl
was a
against
Citrus
Texas.
Bowl against Texas.
That Sunday night, they received their opponent. It was all hands on deck. So I believe those facts are relevant. If this were
mean, it matters.
August and it was a break from the program, yeah, there could be a question. But the circumstantial facts of the timing of these calls, and remember, or I'm not remember, but I will state that at the time these calls were made, Mr. Moore had not been told not to call her and had no idea that she had even gone and talked to general counsel. He didn't know any of that. He was operating in his job.
But wasn't there a call from, or her indication not to call? Or, well, the statement's a little bit different than that.
The statement is she said that she didn't want to talk about it anymore, or she didn't want to talk to her anymore, something like that. Not don't call me, not I'm never going to talk to you again. It was more vague and did not address the employee-employer relationship either. It didn't say, I don't want to talk to you and I'm giving notice. I don't want to talk to you and I'm asking for a transfer. I'm taking 3 days off of work. Don't contact me. That would all be context to show that they were personal calls. None of that occurred.
I think it's important to point out what according to the swear to, at 6 a.m. on December 8th, she told him that she had nothing more to say to him.
Correct.
Okay.
Right. Which is different from I'm taking a leave of absence. Don't call me. I'm taking days off. Nothing about that indicates he should not call her for employment purposes. The point being is that in order for the court to properly evaluate probable cause, the employment relationship is relevant. We can't even evaluate, or we're having a whole conversation about whether or not the call was for employment purposes. The magistrate wasn't even told of the employee-employer relationship. So this conversation in itself is showing that that was an important piece of information for the magistrate to have known, therefore it's a relevant omission. And just one more piece, just going, actually, thank you.
This is cut up,
Thank you.
so if she sounds a little
Mr.
frantic.
Smith.
Thank you, Judge. Does the court have a place at which you would prefer for me to begin or any specific questions?
You can start where you'd like. I guess maybe we should start where the defendant started, and that is the relevance of the work relationship.
I honestly would end there, but if you would like for me to start.
Well,
I can start there.
it's your argument, so I'll let you go wherever you like.
Thank you, Judge. Is it all right if I pace, I think, better when I'm on?
That's fine. I do the same.
Where I start is actually not in my pleadings, and I beg the court's indulgence for a moment because there was a legal fact.
Okay, what the hell kind of stripper heels, bad, like, intimidating posture was she trying to, like, do? And woman, I know you have curly hair, but there's a thing such as a pick when your hair is wet to, like, control whatever is going on top of your head. Why are prosecutors, like, god awful with, like, looking presentable in court? Are you always look like you just rolled out of bed? Like, I know I am in a sweatshirt and a tank top, but, like, I'm not in court in front of a judge. I just can't, like, but she stood there like she was gonna be intimidating with her, like, 120-pound frame and her stripper heels. This is Michigan versus Sherrone Moore. This is the former head football coach of the University of Michigan program. He got fired due to all of this. And I have to go get the little off the potty, so I will be right back.
Actual issue pertaining to this ask that I struggled with at first. At first it was, hey, does Franks apply to arrest warrants? I only know Franks to apply to search warrants. Can I wrap my brain around this? I believe Franks applies to warrants. I've gotten myself there. Arrest, search warrants. I think there's substantial body of case law for you to infer that it can apply to arrest warrants. I think what I struggled with most after that is that defendant's ask has always been that you quash this arrest warrant and that you must therefore at that point dismiss this case. And I see no legal authority for that ask. I have found no legal authority for that ask. I have instead found two Michigan cases that I think address the issue. Maybe not head on, somewhat head on. People v. Burrell and People v. Smith. Happy to give the court citations if that is of assistance. People v. Burrell is 391 Mich 124. It appears to be a 1974 case. People v. Smith is 106 Mich App 203. It's a 1981 case. They
Said Mich App 203?
Say it again. 203. Yes, Your Honor. Thank you. Those cases draw a distinction between this court's jurisdiction and a case existing and your ability to proceed with that case versus the quashing of an arrest warrant. Typically, we think of remedies when a court quashes a warrant is that there is suppression of evidence that flows therefrom, right? That's what Franks is about, search warrant. They were arguing you should suppress the evidence that came from getting this search warrant. What I feel they should be asking, what
I mean, honestly, the clothes are not my issue. Black pants and that blazer is actually kind of cute. It's the, like, holy, like, 6-inch heels, platform heels, and the mop that's on top of her head. Ypsilanti. And the fact that I know how to say Ypsilanti says a lot, right? Like, I told you, I came from a family of Yoopers. My grandparents used to own a house in Michigami. If that tells you anything, that explains a lot. That's why I call myself a Southern Yooper, because every once in a while, the Yooper comes out. And it ain't pretty. Yeah, what the heck is with her hair? That's what I'm saying. I don't know what it is about prosecutors and not being able to, like, own a brush. And I got her in the weirdest, like, freeze frame here. Like,
I can find legal authority for is if there had been any evidence that flowed from the issuance of this arrest warrant, that they could and should be asking for you to suppress that. But this is sort of a backwards kind of a presentation. That might exist in a situation where there was not a warrantless arrest, where they had perhaps conducted an investigation, written reports, submitted them to my office, asked for charges, gotten an arrest warrant, went and arrested, and then perhaps did a search incident to arrest, then perhaps got some statements from defendants. That would be evidence that would flow from the issuance of an arrest warrant. Should you, which I don't think you should you grant a Franks hearing here, and should you further, which I don't think you should, quash this arrest warrant, you're still left with a validly filed complaint. And while, again, I can't find exact case law to spit this exact holding out for us, what I will cite to the court is things like
case law.
the statutes and the court rules that pertain themselves to, let's say, preliminary examination. And they don't talk about holding a preliminary examination and then at the conclusion of which, if the court finds probable cause to bind the defendant over, that you bind him over on the charges in the arrest warrant, you bind him over on the charges in the complaint. Because the complaint is how we start a lawsuit. Civil, criminal, that's what that is. That's the pleading. That exists. So my position is, what I didn't plead, is that even if you granted everything they asked for, you can't get to, they have not shown you authority for dismissing this case.
Well, maybe not dismissing, maybe, but what if there were not, the court were to go through an evidentiary hearing, get to the end and say, well, if the information that defendant wishes and should have been included before the magistrate, that if that information is there would not be probable cause for stalking, then the stalking charge, the complaint would still exist, but the stalking charge would fail. And by necessity, so would the felony, because the predicate offense is the stalking.
And then you would have held the hearing on the complaint. You would have evidence and information on that complaint and get to exercise what we count on you for, which is your decision-making to find or not find probable cause on.
And that's why they're going after the stalking charge, because the stalking charge is what constitutes the felony for the rest of the stuff. If the stalking charge goes away, the rest of the charges are no longer a felony, which is important because 90% of the population probably has a misdemeanor. That's not an exact percentage. I don't know, but misdemeanors are pretty damn common. Drunk in public is a misdemeanor. So if you've ever gone to court for that, welcome to having a misdemeanor on your record. I don't, although I probably should. But this was yesterday. But yesterday I had a migraine and the little was really sick yesterday. So she's still messing with a fever and she's sitting over on her trampoline just in shorts and a tank top in front of an open window, and we're, messy top knot French twist is not a professional look. That's like I just got out of the gym look. Like this is not a professional look. However, I'm also not a lawyer in court. I'm also not a lawyer. There's that.
The charges as they are laid out in the complaint.
I love this chat.
Judge, as to whether or not defendant is entitled to a Franks hearing, of course, my pleading and my position is that he is not.
I did put
Franks
makeup
talks
on.
about there needing to be a substantial preliminary showing before you make a decision to grant a Franks hearing. Honestly,
Okay, this right here, this is not a filter. This is my makeup. This is my new makeup. I will put on a stronger light so you can actually see it. But like, that's not, like I said, I'm updating my YouTube store, or my Amazon storefront with all the stuff that I've been using over the last month because I found some things that I'm absolutely in love with. Sidebar. But like, I can't keep that light on because my headache will come back. However, it looks like she's going for sexy librarian and she failed. Just saying.
Michigan, I think we go better than that. I'll do defendant a solid and say that I don't think that he actually has to show you substantial preliminary showing for you to make that decision. I think People v. Franklin, the 2017 Michigan Supreme Court case, stands for the proposition that this is your courtroom, your motion, your discretion. You get to do that if you see fit. My position is that to do that here would be an abuse of that discretion. I will note for the record that People v. Franklin, that judge clearly had his or her own opinion about the credibility of the CI that was in question, having been referenced in that search warrant.
I think it was all together because the inappropriate, if I'm remembering my timeline correctly, the inappropriate relationship was revealed. There was an initiation of an investigation by the NCAA. And I could be wrong about this. This was a month ago, and y'all know my memory if I'm not like completely following every detail of something. I forget some things, but that all happened at the same time. And I actually think the stalking was first. The stalking is and him being fired is what led to the incident with the sharp object and possible like self-harm all of that. So failed big time. So I don't think I don't think it was an addition of the felony stalking. I think the felony stalking was actually first. I thought he was charged and then rearrested. You could be right. I'm not sure, but I thought the stalking was like the initial thing that led to the inappropriate relationship with a subordinate combined with the stalking was what initially caught my eye. So, like I said, I'm open to being wrong, especially with this being 2 months ago now. But
And so in that judge's discretion, based on that concern for credibility, that doesn't seem to be laid out very clearly in the record or in the written case law, that judge made that decision and it was upheld on appeal. So Judge, this is your discretion, but again, I submit that it would be an abuse of your discretion.
Would it really be an abuse of discretion if I were concerned about the context of the relationship that was placed before the magistrate? Because I'm not entirely clear why Ms. Sharp's statements are even part of the swear-to. But her statements being part of the swear-to creates a certain context of the relationship between Mr. Moore and the complainant in this case, right? So I'm not sure why that's there. The court, from the time I received Ms. Michael's motion, and then your response has had and looked at the swear-to, has itself, before necessarily really closely looking at anything, had a concern about what was put before the magistrate. And mainly because having done swear-tos regarding stalking cases, having presided over a number of stalking cases, one of the, I think, primary things that always comes out is the relationship of the parties and the extent of that relationship. So that the court can take into account why communication may be occurring. I mean, some of the, and you know, let's say some of the egregious ones, there's no connection whatsoever between the parties, but all of a sudden it's happening. And then that creates one scenario. Then you've got other scenarios where you have an estranged husband and wife with children who are contacting. And then a court has to go through an analysis about what the contexts were. So would the court really, would I be in error to have concerns in reading the swear-to that none of that was placed on the record regarding the employment relationship, let alone, might I say, and I'm not even at this point clear as to what the duties are of an executive assistant to a head coach.
I'm equally devoid of that knowledge and information.
But wouldn't that information, right, and but wouldn't that information be important for the court to know?
So Judge, I wonder if I could spit back to you what you have said to make sure that
Sure,
I understand. Because
absolutely.
I appreciate the court's candor. And you told me to start there and I went ahead and started where I wanted to.
Yes.
So here we are, right. There is no question that most relationships have a context. And the court is correct. There is some stalking that exists in the world that is stranger to stranger, and it is what it is. I have encountered precious few of those. Most relationships have context.
most, no,
I think the court
all, lady.
was very much in tune with the reality of this situation when the court earlier was questioning defense counsel and had some commentary along the lines of, but can't both things be true? Meaning, can't there be stalking and an employer-employee relationship? And the answer to that is, but of course there can be. Simply because there might be some amount of communication between two people that is to be expected or a part of a job. But if it is used and abused to threaten and harass and perpetuate more and additional contact, conversation, varieties of contact, it should not negate stalking. What I will say is that I take issue with defendant's characterization of, I think you call it Eichler, E-I-C-H-L-E-R, the September 2025 case that they have cited to you about stalking. I think really what it stands for, my read of it, is it's a commentary, it's a ruling and a holding on the status of the victim in that case, in that they said, because we all know stalking is a subjective and an objective standard to it, right? It has to have made a specific victim feel terrorized, threatened, harassed, molested, that list of statutory factors. The actual victim and a reasonable person also must have felt that way. And so what this case comments on and holds is that it's a reasonable person similarly situated to the specific victim in this case. In other words, would a reasonable probation officer have experienced this kind of communication to be threatening, harassing, molesting, so on and so forth? And the court went on to comment even further about sort of what it means to be a probation officer. And that you deal with individuals on the regular who have difficulty following direction. Court went on to underscore that this communication from this particular defendant did not involve any kind of threats, did not involve going to the victim's home or place of employment. It was simply texts, and they were all able to be characterized as about probation issues. So it is, while it does exist as a case in the context of an employment, if you want to call it that, relationship, it's very specific, in my opinion, to the specific roles that those two individuals played with one another.
Yeah, but that burden rests with the people to show that. Isn't it true? I mean, during the course of a swear to, that would have to be shown to the court. I don't make a presumption that it's one way or another, do I?
It would be our burden to show what
Well, at the swear to, it would be the people's burden, I guess, seeking the complaint to show that somehow those, got to give me something that says it's something other than what might be work related, right?
So I guess what I would then point the court to is that this complaint more alleges an incident on a date. I'm not saying that when we come to prelim here, should we get to that stage and this court orders a preliminary examination, I'm not saying that I wouldn't say to you, Judge, I'm looking to expand that date range. But right now, it is alleged December 10th, 2025. And as we all now know, since we're going to what we know, the defendant was fired. And what we know, according to the complainant, as is testified to in the swear to, he called her 2 times after that. She didn't answer, showed up at her apartment, barged his way in, grabbed the implements that he did. She felt utterly terrorized in that moment, threatened to kill himself, pointed the implements at her, backed her further into her apartment, eventually left when she got her lawyer on speakerphone, and even after he left, then called her, as is witnessed on body cam, called her yet again, and sent her 2 more texts. I hate you, and my blood is on your hands. So on December 10th, and as was sworn to by Detective Welker, there is more than sufficient probable cause for the issuance of a warrant that includes stalking.
Okay, unpopular opinion. When someone texts you and said, my blood is on your hands, they're not stalking you. They're trying to get your attention. They're being an attention whore. They're trying to blame you for their unresolved mental health issues. That is not, I don't constitute that as stalking. I can constitute that as attention seeking, which stalking may very well be attention seeking too, depending on the context of the situation. However, I don't see those text messages as stalking. You know how many times someone's, yeah, that's manipulation, which leads into stalking and is an element of stalking from, just a personal perspective. But unpopular opinion, I don't view those as stalking. That's manipulation and attention seeking. Yeah, they are being a narcissist to control someone with gaslighting. Yeah, and I'm very familiar with being gaslit. Currently being gaslit.
That's my position. I have case law because I have had individuals question me as to whether or not behavior that occurs all on one day can satisfy the elements of stalking, that course of conduct, non-continuous, separate acts. And while it is an unpublished case, Judge, I find a lot of takeaway from this case. It's People v. Smothers. So it's 2025 Westlaw WL 3483111. So it's a Mishat case. It was decided December 3rd of 2025. And it talks about 3 phone calls that took place in barely over 1 hour can constitute sufficient evidence for aggravated stalking.
Were those phone calls answered?
Those phone calls were answered, but none of them, interestingly enough, were answered by the victim. They were phone calls that were made to 911 and either a city manager or a city attorney and the prosecutor's office. And they made threats against a specific deputy and specifically threats to kill. That deputy did not answer those phone calls. They were not made directly to that deputy, but they were communicated to that deputy. And that all was found to be sufficient evidence to sustain a conviction for aggravated stalking. So, Judge, I think on the record of swear to, as it stands right now, when there was no longer any employment relationship because he'd been fired, there were multiple non-continuous, separate contacts that constitute stalking. I mean, I have another case that has barely even 2 contacts that was sufficient for an aggravated stalking conviction, but I'll give it to the court if the court.
But I guess, were the point of those that the information by the caller was communicated to the alleged complainant?
That certainly had to have happened for that to complete that loop. Yes.
Okay. But that's not what happened in this case.
No.
Hong Kong Hero, thanks for the $5 super chat. Prosecutor hair, they get it from surfacing this state. I mean, yeah, she's continuing to try to convince the judge of the crime. I'm not sure. The one thing I love about Judge Simpson is he's no nonsense, but he's also like, he sounds the same no matter who he's talking to. His tone is the same, but he's not condescending. He's just, and Tammy did put a link for a GoFundMe in the chat if you are willing to help or want to help her. If not, I understand, but I did give her permission to put her GoFundMe in the chat so y'all have check it out. If you want to contribute, go ahead and do it.
You're absolutely right. There were the 2 if we're limiting our focus to December 10th, there were 2 unanswered phone calls by the defendant to the victim before he then came over and barged into her apartment and did the acts that he did, and then left her apartment and then called her again and then texted her 2 times. Judge, I would like to address the court's seeming discomfort with a failure to place on the record at swear to that there was an employment relationship, or perhaps what has been portrayed to the court as a disconnect between what Ms. Sharp, the attorney, communicated to the detective and what the victim communicated to the detective. Ms. Sharp, it appears the defendant takes issue with 3 sort of statements or comments that Ms. Sharp made specifically. One is that defendant had been stalking the victim for months. The other is that he has a long history of domestic violence against this victim. And the third is that he is a very dangerous man.
Where's the evidence? Because when Michigan hired him as their head football coach, I'm almost positive that they would do some sort of background check and situation, and because this person will be around children. And yes, they're adults, but they're still 18, 19, very young, very impressionable. And also the head football coach is one of the main players in recruiting high school talent. So I'm sure, I'm almost positive from knowing college football that if you're going to hire this person as your head football coach, you vetted his past history with the law and or questionable things, because he's going to be around teenagers. Most of them his players in college, but some of them high school recruits starting at sophomore age, which is 15. If you're going to have this person sitting in the living room of 15 and 16-year-olds' houses with their parents trying to convince them to go to your college and play football for you, 9 times out of 10, the college vets who they're hiring as their coach. And even though he was an internal hire, I'm almost positive that they still would do shit. And if he had a criminal record or had any violence, because remember, even if you get a police report filed against you, even though it might be false or whatever, there's still a paper trail. So I'm sure if there was any documentation of this, the University of Michigan would have not hired him. That's what's not adding up here, because like the only thing they vetted was his win-loss record. I'm not sure. Yeah, it's a blue blood program. I'm sure they vetted him to the fullest. You're a Big Ten coach. Yeah, he was hired as a coach by Harbaugh. Although Harbaugh is not the most upstanding citizen his damn self, with skirting rules and shit, i.e. Connor Stallions. If you know, you know. If you don't, I'm not taking that time. However, this is one of the premier college football programs with the most money funneled in from boosters. They are going to vet their hire fully so that they prevent shit like this. Yeah, Title IX requires vetting. Hold on.
What I will first say, because counsel calls all of those false lies, and cites to the fact that there is no criminal history, there are no other police reports, things along those lines. Also cites to a follow-up conversation with Ms. Sharp, wherein she says none of the acts that I'm talking about would likely rise to the level of physical abuse in your criminal world. But Judge, I'm sure you would agree with me that there are many different definitions of domestic violence, and also simply because something has not been reported to the police or there is no criminal conviction for it doesn't mean it doesn't exist and hasn't happened. Specifically as it pertains to a definition of domestic violence, I always think of MCL 768.27b, so that other act statute, like when we go to trial on a crime that involves an act of domestic violence and we are allowed to introduce other acts of domestic violence.
Is Ms. Schreiber claiming that?
Hey, baby.
Ms. Schreiber did not, on the day that she was spoken to, December 10th, get into the history of her relationship with the defendant. One person did, and one person did not. Since then, there has been a lengthy additional interview and additional information, but we're not here about that. At that time, that was not something, for whatever reason or number of reasons, she was ready, willing, and able to talk about. She talked about December 10th and the fact that they had had an intimate relationship for a period of time leading up to that. So, Judge, to characterize Ms. Sharp's statements as lies simply because there isn't any adjudicated history of it, that misses the mark. There is no mandate that there be an adjudicated history of it for it to be an accurate statement, or at least an accurate statement in her mind. She goes on to talk about, a specific example she gives of what she means by that is that he has a history of threatening self-harm as a way to exert control over the victim, and that he has a propensity to use knives when he does that. So, Judge, we all know domestic violence includes a lot of things. And that emotional harm, again, I point the court to 768.27b in terms of definition of domestic violence. And certainly it could be causing harm or attempting to cause harm, but it can be placing a family or a household member in fear of physical or mental harm. It can be engaging in activity towards a family or household member that would cause a reasonable individual to feel. And then it lists off all of the stalking variables: terrorized, threatened, harassed, intimidated. Those are all under the umbrella, just in that one subsection of law, of what it means, what domestic violence can be. There isn't any showing that what Ms. Sharp said was false or a lie or inaccurate.
Well, but I think something might be, and this might just come from the court's knowledge of how long the college football season is. She stated to the officer, or to dispatch, I think, or somewhere, that he had been harassing her for months.
Yes.
Now, if I just take months, it's meaning 2, could be more. And I take it from December 10th. that means that he was harassing her as the executive assistant through the majority of the Big Ten season. I'm not sure, and that's part of the court cut. I don't know how that works, how that would even happen.
Because I think that presupposes that the harassment she was talking about is just phone calls or texts that were maybe work-related or that were work-related.
So it was there then placed to be a contact. It wasn't just something that the court should ignore.
The employment?
No, that Ms. Sharp's comments.
It's like she's running around in circles.
I mean, somehow that creates, or it should have created, I guess, a context to the relationship that's going to form the basis of this stalking, in essence, right?
What Ms. Sharp is saying about it going on for months, that somehow will play into what happens here in this
On
case.
December 10th? No, on December 10th. I mean,
Yes.
Well, then why wasn't it all given
Which,
to the magistrate?
which is the meaning that they had an employer-employee relationship.
Yeah, but it's even, and again, I don't know, but I'm just going to assume that it's different than just an employment-employee relationship. I mean, from the standpoint that it's almost like a CEO and the executive assistant to a CEO. I mean, the closeness of that relationship, I just don't know how the court wasn't informed.
If I had to guess, and that's part of what's challenging here because we have one record, which is a transcript, and we're all sort of arguing from things we think we know from police reports and investigations. But if I had to guess, I would guess that it's because the detective assumed that as a fact, as a known fact, if I had to guess. I mean, that's about as honest as I can.
No, I understand what you're saying.
Yeah, I mean, it's one of those that seems like a judicial notice sort of a thing. By that time on that day, that's my best guess.
Well, it may have been a judicial note. I don't know if it would be. All due respect to head coaches around the world, I didn't know they had executive assistants. But whatever. I mean, I didn't know, but certainly the court, through the record, was not informed of that, nor informed what that means. I mean, even as I sit here right now, and I don't know that anybody necessarily can explain to me what it is, I don't know what that relationship is. Like I said, I'm taking it from the standpoint that it's like a CEO and the executive assistant to a CEO, and that is typically a very close relationship. There's a lot of communication that happens. And as I was thinking about this case, the only thing that I could sort of in my head equate it to is myself and my judicial coordinator, and that the communication that flows there is different than I have with any other employee in this court. It just is, by nature of the position. If I'm correct in that, and I may or may not be, I think it's something that the court would have had to have been informed of. Because at some point, even for a probable cause standard, the court's being asked, as I said before, to say that, and maybe the court would have had more questions as to what the nature of this harassment was for these months to create a context of this. Because like I said, I can look at it one way and say, okay, 6-7 games into the Big Ten season, and I can do that by just looking on my phone if I go 2 months back. And I can say, well, if I'm right about the relationship, the employment relationship, I don't know how that happens. And then I might, if I know that, ask questions about that, right? To put a proper context on these communications. So, I'm sorry, you may go ahead.
No need to be sorry.
It would help if I unmuted myself. Unhung Hero thanks for the $5 super chat. The prosecutor gives me scissor me timbers vibes. Which model of Subaru does she drive? Nah, she drives a Volvo. She's too bougie for a Subaru.
My position is that the detective testified to information that was given to her. Was there an omission of employer-employee, that fact? That would appear to be accurate. Again, my best guess is that she assumed that was a known fact. She testified to information that was given to her. The charge pertains itself currently, as we stand, to behavior on December 10th.
Can I just say though?
Sure.
I get what you're saying, but I'm looking at page 6
Of the swear to.
of the swear to.
Yep.
And starting at line 3, basically,
He doesn't sound happy with her.
she stated that after telling him this, that being that there was no more to say to him, that he continued to call her approximately a dozen times and sent her text messages over the next 2 days leading up to the date of the incident. Now, I just stopped there. If I have, it's, and I think everybody's right in terms of there needs to be a picture painted for the magistrate. If Miss Sharp is indicating that there's all of this other stuff that's going on, and so if I'm the magistrate, that's what I'm hearing. Then I'm hearing this, that this individual says that she has no more to say to him. And then there are these dozens of calls and text messages that occur over the next 2 days prior to this incident. Frankly, you'd be leading me to believe the negative because you're not giving me anything else.
Not sure I follow, Judge. Leading you to believe the
Meaning
negative.
that these communications couldn't have been for any other purpose. I mean, because it's equally as plausible that I guess that they could be for the purposes of harassment as for the purposes of work relationships. But by placing it on the record this way before the magistrate, you've given the magistrate no alternative but to believe that it is a continuation of the behavior that Ms. Sharp describes, which I don't know if she substantiated or not. That's my problem.
I think the best I can offer the court along those lines, with the exception of not having sworn to the fact that they were employed together at the U of M,
Yeah.
that Detective Welker passed along the information that was given to her, swore to and testified to the information that was given to her.
Well, I got a problem with that too.
Yeah.
Because part of the problem is my understanding, and maybe I'm wrong.
Do you see the defense attorneys like shaking her head and the judge agreed with her? Like she didn't even have to throw up an objection or anything. She, the attorney was just shaking her. It's like, frankly, madam, I don't give a damn. Yeah, the prosecution is only providing one side. When I understand that the more they can leave out, the more context they can leave out, the better. However, I'm not sure. Like, I hate the state, so y'all just. I know that Sherrone Moore having an affair with a staffer when he is married with 3 kids is a shitty human being, but a shitty human being also doesn't make you a stalker.
But from listening to Ms. Michael's argument, I think I was right now. She has the other text messages from those 2 days, right? Somewhere she saw those, but doesn't say anything about them. Doesn't say anything about what those are. Yet, the one that occurs after on December 10th, well, one particularly,
Yeah.
she lays out in great detail. That I have a problem with because it seems to me, if I were the magistrate, I'm getting half the story.
That's what it sounds
I'm
like.
not getting the full story.
That's what it sounds like to me.
It might be one thing if what was testified to had been, well, these 10, that after that call on the 8th, there were other messages that were sent. They were work related. And then the 10th occurs.
It's like they're trying to conflate the fact that
I just made that up on the fly. It doesn't seem that hard, but that's not what was said. And I'll be honest with you, I find it a problem when the court isn't given all of the information for the court to make a proper determination
And this is why I love
I
Judge.
really have a problem.
Calls out the bullshit no matter what.
Because quite frankly, I think that the defendant's due process rights, as well as the right of the people to be able to proceed with a validly sworn out complaint, are at jeopardy.
Does it impact the court to be mindful that the investigation was then and continues to be ongoing, and that there was always the plan and expectation of getting phones and phone records and further interviews?
That, does it make me feel? No, it doesn't make me feel any better. And the reason it doesn't is because if you think you needed that, then you needed to wait. Okay. But my problem isn't what's going to be gotten later. My problem is disclosing to the court what you have now. So that I realize whenever these complaints are sworn out, and quite frankly, whenever the court may be dealing with a moving case or a case that is, there's always this continuing investigation.
Sure.
So things can change. But so the parties come in, and what do the parties do? They give the court what they have at the moment they got it. All of that could change at some later date. So if you're asking, does that make me feel better? No, it doesn't.
As always, I appreciate the court's candor. I am happy to answer further questions, but my position remains that even if you excise out the statements that defendant takes issue with, calls false, calls inaccurate, what you're left with still is more than enough for probable cause, Judge. If you take the recitation.
But I don't mean to interrupt you, but it's not only taking out certain things. I would then have to add certain things.
You're worried about the omission.
Yeah, I'm very worried about the omission. I'm worried about the omission because those things at the very beginning that Ms. Sharp says create that context to the whole thing. I mean, the whole thing is sort of painted by that. And I think, quite honestly, that's why Detective Walker led with that at the swear to. She's painting this picture, and it's all, I tried to look at it as objectively as I could, looking at the swear to. It's all one-sided when you look at the other part. I think courts are entitled to more than that. You give us everything, let us make the call. That's what we do. But I don't think, well, what worries me, I won't say it in the definite, what worries me is the magistrate did not get that opportunity. That's what worries. And if the magistrate didn't get that opportunity, that means what the people got may not have been a validly sworn out complaint in terms of probable cause properly being addressed, and that the defendant's due process rights may have been violated. That's my problem or my concern. And I don't know how, which is why I asked Ms. Michaels about specific cases regarding omissions, because it's really easy if there is information that's in, and when you look at how most of the courts address it, if something comes in and it's false or it's reckless disregard for the truth, and then the court gets to the end and the court just has to ignore that and then say, oh, is there still enough for probable cause? Quite frankly, that can be a very easy analysis. I don't know well, I won't, I'll figure it out, but the analysis where something's missing.
And I don't disagree with that. I appreciated the court's questioning along those lines. I also am unfamiliar with case law that addresses that concept. My gut reaction has been all along to say that is because those are issues that are addressed at the sort of test the evidence stages, like a prelim, a bind over, trial, things like that. But that's nothing more than a gut reaction. You don't ever want to endorse hiding the ball. You know, that's not who we are. That's not what the system is. That's not what the system should be. That's not what we stand for. Clearly the court is taken with, and again, I appreciate your candor, taken with an omission to put an employer-employee relationship on the record at the swear to. I can't fix that in the moment. I continue to believe the remedy is a preliminary exam. The court obviously may disagree, and if we hold a Franks hearing on that, then we hold a Franks hearing on that. I continue to be of the position that once that relationship is over, there is more than sufficient behavior that was sworn to that satisfies probable cause for the stalking, which then satisfies an element of the home invasion third. I believe that's for sure what Frank stands for, Williams, Franklin, all of that progeny of case law, whereby if the courts are willing to still say there's more than enough probable cause here, even if I excise out legit untruthful statements, which don't seem to in any way have been shown here, not from my perspective. And if there still remains probable cause, then the warrant is valid and there is no need for a Frank's hearing. Then it stands to reason to me that if the worst that we can say exists on that record is a void of a fact pertaining to their employer-employee relationship, that if there still remains adequate probable cause on that record, that arrest warrant should still stand and there shouldn't be a reason for a Frank's hearing. And I think that's probably all I have to say on that, Judge. If the court has any further questions, please.
I do not.
Thank you, Judge.
Thank
I
you.
appreciate it.
Yes,
Response.
thank you.
Ooh, here we go.
The first thing I'd like to address is the position the government is taking that there are enough stalking acts on December 10th after the end of the employer-employee relationship. Count one, home invasion in the third degree, states that it is breaking and entering with.
Sorry, Jeff. I just have to read your comment here because you know I love you dearly. But this is the most like common sense comment. Like, duh. Like, thanks for confirming what 99.9% of us already knew. Believe it or not, that covering of shitty investigators does happen. Yeah. Yeah. And if you're just joining us, hey Snipe, how are you? And Timothy, this lady has an electrified squirrel on her head. Yes, we've been talking about that for pretty much the entire stream since she opened her mouth and started talking. And this is Wednesday, so of course in the Squid household it is laundry day, so you get to join me for court coverage as we are folding leggings and stuff. So apologize for my behavior, but currently the omission of articulable facts is egregious. While Mr. Moore might be wrong with personal relationship, I don't see where the prosecutor is correct in this case. Yeah, it's one of those things of like, do I condone his behavior? No. Do I think that what he did by showing up to her house with and grabbing a pointy object and basically threatening her that he's going to self-delete and it will be her fault is 100% shitty behavior. And barging your way in, there should be a crime from that. But I'm not sure that stalking I'm not sure stalking when it's your boss and he's texting you on work hours about work stuff constitutes stalking. What it does constitute to me is a shitty employee who decided that sleeping with her boss was a good idea. For as much as we are on, here's the thing. We always want to blame the man. And yes, he should have known better, but she also decided to open her legs to a married man. So she's not innocent in this situation either. And I believe now that there was like, everybody knows who she is. She plays it up a little bit more than it needs to be because she doesn't want to look like this horrible fucking person. Because you opened your legs to a married man. I'm not saying he's in the right at all, but in this society, we tend to 95% of the time blame the man and forget that there was a freaking woman involved in this shit too. It takes two to tango. I'm just, it's yep. It's we always man blame. And I'm kind of sick of it that it's like these bitches are opening their legs to married men. Probably for the clout because he made a lot of money because he was the head football coach at Michigan. He made a lot of money. So I'm not thinking she's the most upstanding citizen either. Yet she's claiming to be the victim when if you never would have slept with your married boss, this never would have happened. I'm just putting it out there.
The intent to commit a misdemeanor, and in this situation with the intent to stalk. So in order for home invasion in the third degree to have survive a probable cause analysis, relying on the acts post employee-employee relationship isn't good enough. They have to show that he went into her apartment with the intent to stalk her, which means there had to have been predicate acts of stalking prior to entering the apartment.
And
if they are now saying that the only acts that we are relying on are the acts post leaving the apartment, the home invasion fails. And it should fail because there was no stalking prior to December 10th or after is our position. That's one point I'd like to make. Second point I'd like to make, in People v. Eichler, in paragraph 6.
Counsel, can I just ask one question?
Yes.
In regard to the stalking, you may be very well be right. I don't think it's the time for the court to make the decision as to prior to, but after entering, leaving, and then texting, those could be non-contiguous acts that could constitute stalking.
Too soon to answer that. Honestly, I haven't been. My mind
That means yes. But
no, not necessarily.
No, go ahead.
No, because
No,
stalking,
you're not. I understand why you don't want to answer that. But those could potentially formulate a stalking charge. I might agree with you that the stalking, as it's framed in the complaint, isn't the predicate for the home invasion. I get that, but that illegal entry or potential allegedly illegal entry, and then the text message could do that.
Assuming it can show intent to harass and all these other elements
Understood.
that I would have to analyze, which is why I'm saying I'm not going to answer that until I actually analyze the facts.
That's okay. I got my answer. Go ahead. You can keep with your argument.
But I mean, this right here, there's like 10 things not to do. It's not that hard to understand. I believe one of those 10 things is adultery. But see, and that's the thing. Like, I don't think he's innocent in like the situation either, but we always blame only one party and it takes two to tango. That I'm just saying, like, neither one of them, there's two people that could have made a rational freaking decision here and said no. And if that would have happened, we wouldn't be here. And he'd still be a head football coach of a Big Ten program. Yeah, like, it always takes two people. And I'm so sick of, in society, we tend to blame the man. You see, am I the a-holes and like reaction content? And vast majority of the time, it's blaming the man and siding with the woman. And I'm not saying the man is innocent. I'm just saying it takes more than one person to get yourself in this kind of a situation. Yeah. That is true. I do understand that, but that is not the only part of the equation. The part of the equation is her saying no or never starting anything either. So both are in the wrong, but for her, and the problem I'm having with all of this is the home invasion is completely opposite. But like when you are sleeping with your boss and then all of a sudden like things go to shit and then you claim stalking and he's been stalking her for months. Well, you don't have a paper trail. If he's been stalking you for months, one, why didn't you file a complaint with the university? Oh, wait, because you would have had to admit that you fucked up, and that takes accountability. And it's like she's not, it's like there's no accountability on either side. Yeah, true. And I understand that, but it's just like, he's still nuttier than a squirrel turd. Well, you know. And hey, Devil Fan, how are you? Yeah, he couldn't get a better judge than Judge Simpson, but it's the stalking charge, like the other stuff, totally like, but a stalking, like they will tell you for months that you need a paper trail because just texting doesn't do it. Like when you are stalked and you go to the police and someone is stalking you, They will tell you you need a paper trail. They will tell you, well, being in the same place isn't like we've gone over what is stalking and what is not 1,000 times because people were looking for evidence that I was stalking them when I have no idea who they are or like I could care less or couldn't care less about people. So we've gone over a lot of times on this channel of what is and what is not stalking. And your boss texting you no more, and this is the important thing. The prosecutor never mentioned that he was texting her any more than any other staffer on his payroll. Just, if he's texting her 6 to 5, 6, 7 times to every one text message he sends to everybody else, that would be something important that I'd point out to prove a pattern of obsession. But she never did that either. And that would be something super simple to say, well, the amount of text message based on the information that we've gotten from subpoenas and, phone records is that he would message her this times, 6 times more, 7 times more than any other person on staff or any other female on staff even. If I wanted to look for proof of stalking, that's one of the things I would do. I would pull phone records and I would look at every other female on staff and see. And if I saw a pattern, then I would compare it to the males. I'd actually investigate. I wouldn't just throw shit around without any evidence.
But it's important, though, as to the felony. I mean, a felony is much more serious than a misdemeanor. So if the stalking fails as to going there with the intent to stalk, breaking and entering with the intent to stalk, that would have to have been a second or third act. You can't go and do something.
I'm not saying I'm disagreeing with you. I'm just saying
Thank you.
that you made a statement
Understood.
that I might disagree with, but go ahead.
The government also pointed out that there, in the fact pattern that she just relayed to you about Mr. Moore walking towards the complainant while he was holding the butter knives. I'd like to point out that
it was a
the
butter
prosecution or the charging agency, they're the ones who get to choose. They didn't charge him with assault or aggravated assault or any assault. They looked at the facts and didn't even ask for that. So to describe him as dangerous and assaultive, they didn't even see that as assaultive on that day. I just want to make that point. Finally, the prosecutor also stated that there was further conversations with the complainant to flush out more of the history. That conversation occurred prior to the swear-in. The in-depth conversation with the complainant was documented in the police reports and is on body cam, video, audio and video. And at no time does she describe a history of domestic violence or a history of stalking. And one more thing is,
oh no, there we go.
as I was getting to Eichler, paragraph 6 the government tried to say that Eichler can only be applied to cases where it's a probation relationship, that it's limited on its facts and should be seen as limited in its holding. Eichler actually.
Yeah, but she went to the university after months of supposed stalking. Like, wouldn't you, and I'm sorry, like, I would go to the university. I don't care who you are. If you're the head football coach, you're the lowest level staffer, you're the president of the university, I wouldn't care. I'd go and complain. And also going to complain about to the university instead of going to the police, because there's no record that's been introduced that she ever went to the police. If I'm going, and I'm not trying to defend him, I'm just pointing out things that don't add up to me as a woman who has gone to the police for things. Let's put it that way. I would not go to the university. If I wanted revenge and my petty revenge side, something happened between the two of them. She goes to the university as revenge and vengeance. You fucked me over, I'm going to get you fired. That's the mentality. If she truly felt scared, you would not go to the university. You would go to the university police And that's what she didn't, there's no record that she ever went to the, yeah. If she was in fear, she should have informed the campus police at a minimum. Because then the campus police will be like, either handle it or they'll be like, this is out of our whatever and go to the city. But that, as far as what the prosecution has presented, never happened. Just calling balls and strikes like I see them. You don't have to be a good person. I think he's a shitty human being. But I don't think that she went to the university because she was scared. I think something happened between the two of them and she went as petty revenge. And that's my petty side talking. Because that's what I would fucking do. You fucked me over. I'm going to fuck you back. I'm going to take your job and your millions of dollars in paycheck. Yeah.
States that the language from Eichler is this, that under Spalding, which is a case that they're citing, a reasonable individual is a reasonable person similarly situated to the victim, which necessarily means that we must consider Meyer's chosen occupation, training, and job-related responsibilities as part of our consideration of the circumstances or situation. It doesn't say we must consider one is a probation agent and one is a probationer. It specifically generalizes to the relationship between the parties, the
And I don't think that is 100% true, but, you know, and I don't know why this just, there we go.
Finally, if there was notice at all that, well, he's the head coach at Michigan, who knows that the complainant was his executive assistant? I put out there that is certainly not anything someone would take for judicial. I'm
just going on what has been reported by the prosecution, because if the prosecution said that all they said was this has been going on for months, but they never provided evidence that she had mentioned it to the university, that she had gone to the campus police, that she had gone to the city police. There was no paper trail. There's no long-term text messages that have been shown prior to December 8th, 9th, and 10th. So if I had evidence, I don't know, in an evidentiary and motions hearing, I'd fucking present that evidence. And the prosecutor either is completely stupid or doesn't have the evidence. And really, I'm not really sure what is true because she doesn't seem like a very good prosecutor in the first place. But yeah, in my opinion, I don't know anything. It smells like the basis for a settlement payout or two. And that, yeah. I'm not, yeah. Because I'm sorry, if I'm being stalked or I feel threatened, I'm going straight to the police. I did it when Bruce was acting foolish and threatened to call CPS on me. I said, if you do it one more time, I'm going to go to the police. And I ended my stream and I went straight to the police in my town and filed a police report because I'm not fucking playing any games. And even though I didn't think anything was going to happen, I wanted a fucking paper trail that said I had gone and bitched about this before. So if anything did happen, I have a paper trail. She never did that. So either she's stupid. There's just shit that doesn't add up from a basic, like, fundamental shit, except for he was making a lot of money. You slept with a married man. She seems like the shitty person. She doesn't seem like the most upstanding citizen. And then when he kind of pulls a little crazy stunt, and then she's like, oh, he's been stalking me for months. At any time, you could have gone to the police and said that he was stalking you. At any time, you could have gone to the university and said that he was stalking you. She went to the university and said that there was an inappropriate relationship. And the only way you tell on yourself with an inappropriate relationship is when you want revenge for the other person involved. Shitty human being. Yeah, paper beats rumors. Yeah, paper trail leads to proof when you have no receipts and your accusations fall flat. Yeah, it is unlawful to communicate with intent to threaten, friend. Yeah, and December 8th, 9th, and 10th, when she went to the university and said about the inappropriate relationship, and then the shit hit the fan, like, overnight. totally understand that. And I'm not saying he's innocent of that. But when you're saying months of stalking, months of harassing text messages, and you cannot show them, I find that to be a big problem. When you only go to the university after your relationship breaks down. Yeah. I'm willing to have an inappropriate relationship, but not with her. Yeah, and I don't think he's innocent in that at all. But the sounds of it was she only went and told on herself when she thought she would have something to gain.
Notice. I suspect that nobody knew that relationship until this incident happened. And if I may just confer with co-counsel briefly.
So it's just one of those things of her story doesn't add up from a basic psychological standpoint. If you're in
One last point to
fear-
make is the prosecutor
No,
presenting to your honor that it is a known fact that Sherrone Moore is the head coach at Michigan. That known fact would be from the media, from the news, from various other places, and it's improper for a judge to rely on that kind of information at a swear to.
Let me just ask one other question. Let's say, hypothetically, go through the entire thing. We have the evidence you're hearing. What do you believe the proper remedy is?
I think the proper remedy is it's a couple step process. I think first, after the hearing and the evidence is presented, and your honor makes a determination of what was not true or recklessly presented because it's unsupported, and that is taken out, and then the omission is put back in, I believe it would be on your honor to then evaluate based on controlling Michigan law to determine if there's enough probable cause to support this not only the warrant, but the swear to. Not only the swear to for the warrant, but the complaint itself. The complaint has to be accepted by the court. The prosecution doesn't just, there is a process for your honor to review a complaint and accept it. So I believe a dismissal of the complaint would be appropriate remedy. I think a secondary remedy would be to suppress any and all evidence obtained after the arrest.
I guess maybe I'll put it more directly. Let's say you were to win on everything.
Yes.
There would be nothing that would prevent the people from seeking reauthorization.
That is correct. And it is my belief, based on my review of the materials, my investigation of this incident, that they wouldn't have probable cause to make these charges. I don't believe they have probable cause to make these charges.
Regardless, you just don't think that there is.
I believe when presented fully and fairly to a magistrate, I believe there is not probable cause to support these charges.
Oh, damn.
And I believe there's less probable cause now than there was when the incident happened.
I don't know what that means.
I believe that the evidence that has now been collected will show that there was not stalking.
Right, but
that's what I said.
Right now, I'm not dealing with any of that because you're, for the purposes of this motion.
Right, you're asking me, I believe the question was, let's say I win and everything's dismissed, they can go and just refile. That was the question, correct?
Yeah, there would be nothing other than the fact that there might not be enough evidence to do so to prevent them from doing it, right?
It's my belief there won't be enough evidence to do so.
All right, very good.
Thank you.
Thank you.
And I
All right.
agree with her.
Thank you, counsel, both of you for
We're not here.
your argument and the manner in which.
They're not there discussing the home invasion or the text messages that said you ruined my life, blah blah. After she went to the university and the shit hit the fan. They're discussing the stalking, and I think the defense is coming at it from the stalking the underlying stalking charge is what makes all of the other stuff a felony. But stalking implies more than 2 days worth of 2 days worth of unwanted contact. Like it's more than just a couple of text messages. And when she said months, nobody has shown any evidence of months of stalking, yet that's what she told her lawyer. But if you remember back to the beginning of this hearing, she never actually said that to police. So she said it to her lawyer, or her lawyer said it to police. It just doesn't make fucking sense from a victim's perspective. And she's not innocent by any means in any of this shit. She's going straight for dismissal on probable cause. That's a little ballsy. I think more of the stalking charge, because other than that, it gets lowered to a bunch of misdemeanors, which yes, still sucks, but misdemeanors generally don't have jail time or take away your voting rights or take away your right to own a pew. Whereas a felony conviction takes away some of your God-given rights. Yeah. I believe that's an element. I'm not even gonna lie. Like, why would he stalk her? I'm baffled and somewhat confused. They were having an affair, not innocent, but it takes two to tango. And she didn't go to the police and say, he's stalking me for months. She went to the university and told on herself that they were having an inappropriate relationship and that they were sleeping together. And I believe at the time she said she was pregnant. That was a rumor. I don't know if it was ever confirmed. But she went and told on herself. And the only reason that you go and put your own job in jeopardy is when you want petty revenge. I'm petty enough to, she is saying that nothing was criminal, and when she refers to fabricated evidence is excluded and state will not be able to bring forth and refile because what's known now. Let's hope so. I mean,
You answered the court's
I think it's
question.
just
and the court does
still
appreciate
not
it.
dealing with that. But
I'm going to take a break. I will come back with my decision. I would.
Exclusive.
Why don't we look at it this way? Just give it time to come back. It may not take me that long to formulate everything, but come back on the record about 4:15.
I remember that, and I hadn't
We'll make sure that they know and get them down to
confirmed or denied.
Court stated recess.
All right.
7:30. Like I said, I was prepared. I did the. I know when the court was coming back. Like, see, I did do some work. I appreciate him not wearing an earring into court, even though he has his ears pierced. Hey, Comic Queen, your neck of the woods. I love Judge Simpson. I think Judge Simpson is an amazing judge, probably an even better human being. I've watched him for a long time. So the fact that he's he's the judge on this case is like, I love it. I mean, I'm sorry that this case was even brought or this whole situation had to happen. I would rather see Sherrone Moore as a college football coach, but here we find ourselves. And sorry, y'all, it is laundry day. So we're folding laundry. And thank you, Heidel, for sharing my other channel. I have a second channel called Evidence Through Motion. It's my baby. The judge that put away Nasser is an Army vet sister. Interesting. I didn't know that was the case. So, not Squid's channel. Yes, I go by my actual name on that channel. So, since most people know my actual name anyway. But I went to college for occupational therapy assistant, and that's where I actually use those skills. Since after COVID, we never working in a hospital again because I saw shady shit, and I'm not going back. So let me skip. We don't like to waste time on here. But hey, Foxy, I have laundry in the washer. Thanks for the reminder. Anytime. Nice. Were you Army? I was Navy.
Back on the record in the
I'm part of the
case of the
test
people
tube.
versus Sherrone Moore.
Yes, Devil Fan is part of the test tube for that channel as far as the links for one-on-one sessions. Devil Fan is my test tube with virtual training. So if you have questions on what it's like to meet with me one-on-one, he is the person to ask. COMMO is short for communication. See, we just called it comms. So I'm Navy. We have a little bit different. We're similar, but we call things different, and we get like. For a while, I didn't know what a damn MOS is, but I know Army people that didn't know what a rating was. So we're similar but different. I couldn't believe what people did in hospitals when they didn't deal with patients' families. it was sad. It was sad. But
Counsel is present as well as the defendant. And I, first of all, again, want to thank counsel for their well thought out arguments, and most of all for answering the court's questions, which since the filing of the motion for Frank's hearing and to quash the arrest warrant have been part of this court's this extended thought process. The important thing to the request for an evidentiary hearing pursuant to Frank's is, first thing to realize is that in Frank's, in the Michigan Supreme Court has made it very clear, Frank's, the requirement of an evidentiary hearing and the like based upon Frank's is the floor and not the ceiling. Michigan, I think as the people have acknowledged, allows greater leeway and discretion for courts to hold evidentiary hearings regarding issues involving a search warrant, arrest warrant, or warrants, where it is in some way demonstrated that there is either evidence which is intentionally or unintentionally, in certain respects, misleading or false, or where there is almost a reckless indifference for the truth. This case brings up sort of a different issue, but brings up the issue of an omission. What is clear from this court's perspective with these is that an omission in certain contexts can be more damaging, more problematic, more troublesome than what might be an intentional misrepresentation. In either way, or in any event, this court is of the belief that at every proceeding, every representation made to a court should be a full and complete representation to the court so that all the parties can receive their due process. That includes the people, it includes the defendant, and anybody else coming before the court. The defendant wishes this court to have an evidentiary hearing regarding the issues, but fundamentally it's focused around certain portions of the omissions and sort of the context, particularly as I gather from the defendant's argument, and what has been a concern of the court is the context of the relationship. People, on the other hand, don't believe that the court should hold an evidentiary hearing and that it would be an abuse of this court's discretion, which it has the discretion in, but it would be an abuse of that discretion to hold an evidentiary hearing.
That
An abuse of
that
discretion,
doesn't make
what
sense to me.
is very clear from the case law, only occurs where the result of the court's decision or use of its discretion is outside of the range of reasonable outcomes. I don't believe that granting an evidentiary hearing in this case would be outside the realm of reasonable outcomes at all. And just by way of context, in looking at the swear to by Officer Walker, what's clear, and also from the court's question, I think the parties realized where the court was going and should have. The initial part of that swear to is not set out by the representations of the alleged complainant in this case. It's all set out by her attorney, Ms. Sharp. Virtually every statement is a rendition of what Ms. Sharp said to the police. It isn't until a little bit later into that swear to that you get into particular statements that are made by the complainant in this case. When one looks at the Eichler case, one of the things to realize and where the defense was heading is that the context, and I read it as broadly as the defense does, that context to stalking charge, context of that relationship is critical to an assessment of that relationship and whether or not there's this harassing behavior or stalking going on.
Thank you.
As I said, I can only imagine, but this court doesn't know what an executive assistant to a football coach does. I don't know if phone calls or messages might be exchanged all times of the night. I don't know any of that. I can only presume that if they are the executive to effectively a CEO, the range of their responsibilities, duties, communications is vast. But again, I don't necessarily know that, but it's something certainly that the court should have been informed of during the swear to. it's gone without any rebuttal that the phone calls that were alleged or alleged to have occurred during work hours, occurred during those times at which I guess most might think communications would occur. That the written messages in terms of text were admittedly employment related, at least is what's been represented to the court. I don't know why that wasn't given to the magistrate. I
I
think
can give you a guess.
that the evidentiary hearing would be necessary because there's no mention of the employment, that context given to the relationship. The context during the swear to is a one-sided rendition of things by someone else. It isn't, it by no means would constitute a full picture. More important, and it may go to the defendant's argument, although they didn't place it this way. I asked what might be particularly false in their statement. That's a tough question to answer, and I appreciate the response that I got. But really, I think that the falsity really comes in the way that it was sworn out. It at worst is false and an outright lie, excuse my language in that regard, or at best, it is misleading. And particularly when it talks about the 10 to 12 phone calls and text messages, there's not one mention of the fact that those to which they could determine were work related. There's not a mention of it. That is a huge, in this court's perspective, that's a huge omission. Because immediately afterwards, again, there's like a statement from the complainant about these 12 calls, making them seem as though they are somehow related to some type of harassing behavior because there's nothing on the other side to say what it may be. And then the immediate statement afterwards is a text message that came after the incidents or later on the 10th, after the issue regarding the complainant's home. Frankly, I think that was intentional. I think it was intentional to place a context without saying it. Give the court a context. If you look at the very beginning, that he's this monster, he's this person that's been doing all of these things, been harassing her for months. You lead that down into all of a sudden this day comes along or the 8th of December comes along. There are these 10 to 12 phone calls, which one might presume would be a continuation of the harassment, but we now know are not any type of harassment. And then the December 10th incident. I don't believe a lot of times in coincidence. I don't believe that things happen all the time by accident. I agree. I think that was an intentional misdirection to the court in terms of what this should look like. That doesn't mean that I would end up any place different than where the magistrate was, but the magistrate was owed the benefit of having all of that information prior to making that decision. It is in this court's mind glaring.
Where I'm thinking he's going with it was the swear to was only one side of the equation, and the magistrate and even him have not been provided with the full picture. Only what Miss Sharp, which is not the complainant in this case, has said. And that is not, in my personal opinion, not the way to run a courtroom, an investigation, any sort of case. I know that it is the prosecution's job to present the facts that paint them in the best light. However, there is a certain threshold that you have to meet of providing both sides with information. They're both sides of a story. And it's just shady. And it's one of those things of like, just because we think something is morally and ethically wrong doesn't make it legally wrong. I'm not being very controversial today. Want me to leave a thumbs down and rage quit to keep up the streak? See the first 5 minutes of the stream for those of you who are wondering why I'm not very controversial, because there's going to be some changes on this channel because I need to put my focus on other things, but we'll get to that at the end of the stream.
omission. To leave out or frame this relationship only in one way. That doesn't mean that it doesn't intertwine itself between the personal and the professional. It doesn't mean a lot of things, but this was not solely this personal relationship. And the magistrate should have been able to look at that and determine what it would be. That you can tell right on the surface. I would suspect as you dig deeper, there would be other issues that aren't painted in their full context in terms of what happened. So for those reasons, the court, in exercising its discretion, is going to grant the motion for an evidentiary hearing in this case to be held. And counsel, I'm going to have a couple of questions for you. One is in regard to availability, and I would indicate to the parties that I would like to hold the PCC date if possible. So I'm looking at getting to this in quick fashion. The other issue I would have, or a question that I would have in setting a date, is what witnesses you would anticipate calling. And I'll start with the defense.
Have a moment, Judge.
You may.
Yeah, working on that too.
Be the government's burden of going forward to show that this was done properly. So I guess maybe I can respond after they tell me who they would be calling. I don't know that I would be calling anybody once they put their case on.
Really doesn't matter to me who goes first, because I'm going to get to where I'm going to get to. Do you have what witnesses you would anticipate calling? Understanding, and both parties just need to understand, I think I made it clear as to where my reservations and concerns are. And you folks are going to know those witnesses that would be able to clear it up the best for the court. So.
I mean, off the top of my head, Your Honor, I think the court, I would imagine, would want to need to hear from Detective Welker, from, I would imagine, the victim, and from Ms. Sharp. Whether I should present to the court anybody other than those three is something I would, I guess, ask for a little bit of time to think about. Those seem the obvious ones, Your Honor.
Understood.
And if the court, I mean, I get it's my burden and my presentation, but I am mindful of the court's thought process, continue to be appreciative of the court's candor. If there are witnesses that the court would like to hear from, I would consider it my obligation to bring those to Your Honor.
Well, let me ask this. Were there officers that were part of the interrogation process or the questioning of the victim in this case?
There were a couple, yes.
That were, so, and the only reason I say those is because Detective Welker presumably would have received that information from them, or at least that's a possibility.
Some of it, yes.
Okay.
Yes.
So I think the officers that may have interviewed the victim in the case.
There's at least two more that I can think of that off the top of my head.
Can I have one moment?
Sure.
Thanks for your patience. Princess wanted the other half of her treat.
The officer who had a body camera on at the scene would likely be a witness, or potentially for purposes of impeachment if necessary.
But that officer, and maybe that's who I'm kind of referring to, because that officer was one that I can't remember. I think somebody referred to it in something.
Michael Barlow, who was the original respondent.
Right.
Officer.
That's
so
it.
That I would think would be for sure. Yeah, there were a multitude of other officers that came and went from that apartment. All of them had body-worn camera. Some asked additional questions. Some asked mostly repeated questions. There was one officer who did a follow-up phone interview, whose name is escaping me right now, Peterson, and that is a recorded follow-up phone call, Patterson, with the victim. So those are two for sure. If you're looking to hear from and see body cam of interactions with the victim, so Escobar, Lorca, and
The prosecution doesn't want to see him to have an
counsel will
evidentiary
like-
hearing, because if she has an evidentiary hearing, she has to show evidence, and I don't believe there is any. Based on everything she said, I don't think there is any. I think this investigation sucked. I believe the complainant's lawyer is lying. And I believe she wanted a quick payday. And when she didn't get it, she went to the university and ruined his career and ruined her own. And the only time, like I said, that you go and ruin your own career is when you want petty revenge.
All of those who responded, who had body worn camera, there's duplicated effort there, but
I don't know. Well, the court would have to see body worn camera. As long as there's an admission as to its foundation, I don't know that we're necessarily going to need the officer there per se. I mean,
Yes, we can talk about that. We could probably stipulate to the foundation of those body worn cameras. There was the initial officer who talked to the complainant, and then later on, maybe a half hour later, there was a follow-up interview on site. I'm not sure if it was the same officer or not, but we'll make sure we figure out which body cams are relevant.
anybody else you can think of?
That's all I can think of.
does the coordinator want the officer that took statements from the defendant, as those are also referenced in this route?
I think that would also be pertinent to have that officer.
If you see me sneeze, it's because I'm about to close my windows because somebody
Suggestion.
is smoking something and
Council and I can communicate about hoped for, anticipated, expected witnesses. If I then compile a witness list, serve it on the court and council with perhaps a reference to this very normal first responding officer,
Yeah.
the phone interview of victim. If then there are additional witnesses that anybody would like to hear from, I can consider it my responsibility to make sure.
All right, great.
That works, yes.
Okay, very good. Okay. I'm just looking at that. This is going to be an all-day affair release.
Yeah.
So, and those of you that practice before me know that that's usually limited for me. However, I would have can cancel dockets. I would have
No,
March
it's
2nd and March 9th.
Like, they have a pork butt on the smoker. I can smell it. But
So I would have
Right
March
in the
2nd,
window.
March 6th, or March 9th.
Currently have a murder trial set to begin March 9th, might be resolved in the process of doing that. So in light of the 9th currently being occupied, the 2nd is the best bet.
Okay.
Followed by the 6th, followed by, in the moment, not the 9th, but they may all wind up being good from my perspective.
Got
it. Thank you.
I prefer the 2nd, March 2nd. I'm available that day.
It's not Groundhog Day, so.
they're smoking some sort of food
Yeah.
item. And I can
Okay.
smell
We'll
the-
set the evidentiary hearing in this matter for March 2nd, 2026, 9 a.m.
March 2nd, 9 a.m. Yes, Judge. I will be
Counsel
here.
for the defendant will prepare an order consistent with the court's ruling today.
That's a Monday morning.
All right.
Ugh.
Is there anything else from either side?
No,
No? One question I did have, I know that at our probable cause conference, there were issues regarding documents from the University of Michigan. You had indicated that you may ask the court for a subpoena. I was having my staff on the out look for that. Has that been resolved in any way or not?
I have not done that yet. I want to have a conversation about that as well. Sure.
All right. Why don't you guys talk about it? Just
Hey, Tammy.
It's one of those things on my checklist that wasn't checked off. So,
Right.
all right, folks, thank you very much.
Thank you.
Bond will continue. Court stands in.
All right. The prosecutor, it sounds like she's not sure what to do because I don't think she knows what to do. She's kind of having, in my opinion, and I'm going to give you my final thoughts because it got to go soon. In my opinion, she doesn't have a case. She knows that the investigation was shitty. And by having an evidentiary hearing, she has to show how shitty the investigation was and that the complainant never actually said any of this to the police. Her lawyer did, or whoever whatever her freaking name was, Miss Sharp is. I believe that's her lawyer. But it's like there's no case. And they say months of stalking generally has a paper trail. And you don't go to the university exposing your relationship. You go to the university saying he's stalking me, and your relationship might come out later as a part of the investigation. However, she went to the university and said, from what I can gather, and what's been reported, that she told the university about their inappropriate relationship. There is no paper trail of the stalking, and the stalking is what predicates the felony charge. If you get rid of the stalking, he's left with a bunch of misdemeanors where, I'm sorry, I don't see him innocent of like the home invasion and that part of that piece of the equation, but the stalking part just seems very bullshit to me. Yeah, my bet is the state moves for dismissal. And this is why it's important in every investigation for you to cross your T's, dot your I's, and not be a shitty cop. Just saying. Like, I know it's not my job, and I know it's difficult to run a thorough investigation, and it's time consuming and mentally draining and all that shit, but that's your job. Sorry. Well, yeah, but that's a misdemeanor. That's not the felony. That's not, if the stalking is added to it, that makes it a felony. I got to look at the Michigan statutes, but with the stalking gone, he's left with a couple of misdemeanors, which, I'm sorry, if I were to be charged with something, I'd prefer misdemeanors over a felony any day. I'm just saying. So on that note, we have to get going because I have to go to work in a couple of minutes. I have to go to work in like half an hour. However, we will have a stream tomorrow. Next week, stream times are changing. Well, not times, but dates are changing. We are no longer doing Monday through Thursday, and then ends up Friday, and then Saturday, and then Sundays on my other channel. This channel is streaming 3 times a week. Tuesday, Thursday, Friday, at 2 p.m. Fridays might be a little different based on mine and Mr. Squid's schedule. However, 2 p.m. Then Saturdays will be a bonus day for either trial coverage, collaborations with other people, things like that. Because I am taking some time away from this channel and focusing so much on this channel, because I want to focus on not only prepping for my CrossFit competition in April. I'm a mom right now of a sick toddler, so I literally have the thermometer. I'm going to go check her temperature again. I am busy all the time, working outside of the house 2 to 3 times a week, depending on the week. I am seeing clients one-on-one now, and I want to grow my other channel because that is my passion project. That is what I went to college for. I went to college as an occupational therapy assistant. I have a lymphedema certification, and I am a certified or corrective exercise specialist. That is where my passion is. This channel is fun, but that is where I want long-term growth. However, we do have a link. Y'all know my favorite product right now that I'm using is this right here is my other channel. I do have a favorite product that I'm using called the Tallowed Truth. It's grass-fed beef tallow. I use it as a lip balm. I use it as a cuticle oil, and unfortunately the little took it, so I don't have it at my desk. However, I did work with them to get a link, so I am now affiliated with them. So here is my my link to the Tallowed Truth. If you check them out and you make a purchase, you are helping my channel grow. Appreciate it so much. I will see if I can eventually get a discount code from them. We shall see. I'm not relying on that. However, I am now affiliated with them. So if you make a purchase, it helps my channel and I appreciate it. They are grass-fed. It's beef tallow, honey, and frankincense. It doesn't smell overwhelmingly like beef. So you're not going to walk around attracting, all the animals in the neighborhood aren't going to come find you because you smell like beef. It doesn't smell overwhelmingly like honey, and it definitely doesn't smell overwhelmingly like frankincense. It's kind of a nice blend of all three, and I use it for everything because I'm trying to eliminate chemicals in everything. I'm not super like, oh my God, we have to eliminate everything. But we get enough chemicals in our water, in our food, in our products that we put on our skin, which is our largest organ every day. So I'm trying to eliminate, and if I can use more of a natural product on my lips versus whatever is in some of the lip balms and like the ingredients list, even though I love this one right here, the ingredients list is like 10 or 15 things long. And I'm like, this has an artificial, this right here has an artificial dye in it. And you're putting this on your lips all the time and ingesting that. And it's just not something that I want to do anymore. There's enough things in this world that are hormone disruptors and all of that. And if I can eliminate some of them by using something that's a little more natural, I'm all here for it. But I did work with them to get a link. So that is a link for you. I just got it like today. I opened my email while we were streaming. So that's all I can say for that. I passed up the organ comment. Aren't you proud of me? Yes. However, I will see you guys on my next stream tomorrow. We have a couple of things to talk about. I'm not sure what the topic will be yet because with not streaming yesterday, got a little behind on things, and I also need to look up some cases. Wanted to cover this live yesterday, but didn't exactly work out. So we will see. I might do some more updates on the NIL lawsuit with the University of Georgia. We shall see. Anyway, y'all have a good night. Take care, and I will see you guys on my next one. Bye.